Okay, so we're live now. People are joining in.
Okay.
Let's just wait for a couple of minutes so that everyone joins in and then we'll begin.
Yeah, absolutely.
Okay, I think we should begin. Welcome everyone to the webinar. So, as you guys might know that intellectual property is territorial in nature, but a very important and a very unique feature of intellectual property is that there are a lot of treaties that bind a lot of nations with the kind of laws that are in place today in various countries. Having said that, there are definitely some differences in intellectual property laws in various different regions, in various different countries, be it common law countries or civil law countries. So these things are definitely to be noted and to be learned if you either have a client who wants to get a registration in that country, or you want to in future someday want to kind of function in that country, or even if you are a paralegal who is willing to provide their services to people just sitting at your home remotely. So just for that purpose, we have with us Ramya today. Welcome to the webinar, Ramya. Ramya is a qualified advocate in India and is now a solicitor in the USA as well. Sorry, UK as well. I'm sorry. And Ramya had been working in the field of intellectual property from past 10 years. She graduated from University of London like she did her LLM from University of London intellectual property, and is now working in the UK as a solicitor. So without further ado, let's begin with today's session, wherein Ramya shall be taking us through various aspects of trademark law in the UK. This will be more of an introductory session on UK or laws for trademarks, wherein we shall be touching upon various aspects of the law. So let's begin with the session without any further delay. We can begin, Ramya.
Good evening, everybody. Thank you, LawSikho, for organizing this webinar. Thank you to all the attendees who are making time to attend this seminar. Obviously, I will just try and first share. I've prepared a PowerPoint presentation. It's easier to have something to refer to. I'm sure Abhishek and LawSikho team will most likely circulate this. I leave it up to them. I'm going to try and first share my screen so that we can kick off this webinar. Abhishek, you have to give me permission to share the screen, I think.
Can you check if you can share now?
Yeah.
Okay, great.
Sorry, apologies, everybody. I'm just trying to do that now.
No problem. Please take your time now.
Abhishek, I think I have an issue with sharing my screen. What do you think is better? Is it just easier for me to kick off the webinar and then you can circulate the PowerPoint? Is that?
Sure, we can do that. You can refer to the PPT and then I can circulate it later. No problem.
Okay. So apologies, everyone. I'm unable to share my screen today. It's mainly to do with my privacy settings on the iMac, so I'm very sorry about that. But just to kick off the webinar and not waste any further time, today we are looking at a very brief introduction into the UK trademark law. There are only some topics that I will be discussing today. So mainly we will look at the registration process in the UK. So I will cover definition, search and filing, and timeline of how long it may take to actually proceed from application to registration. Grounds of refusal, mainly what are the grounds that an examiner at the UK IPO will raise when an application is filed. We will briefly look at grounds of opposition, but I will not touch on any case law on this particular aspect. And we'd also look at registration, what is non-use period in the UK, and how do you renew a UK trademark? And lastly, and a very important aspect now because of Brexit, is to look at Brexit and its impact on the UK trademark law. So just to give you the sort of skeleton of what the UK trademark law relies on, we have the Trademarks Act of 1994, we have Trademark Rules 2008, and we also have a manual of trademarks practice, which is mainly used by the UK Intellectual Property Office. In short, they are referred to as UK IPO. It mainly sets out guidance on the office's practices, and that can include a number of aspects. So it can go from classification all the way up to appeal and opposition proceedings, etc. The PowerPoint obviously has links to many things, and I'm sure when you are able to see it, you can have a read through those links as well. So if we go, so I'll start with the first topic, which is trademark registration process in the UK. What is a trademark? This is not a definition from the Act, but mainly a more sort of what I would call as a commercial definition. This definition has actually been given by the SITMA, who's the Chartered Institute of Trademark Attorneys. They're a regulatory body who regulate trademark attorneys in the UK and in the EU as well, if you are qualified in the EU. A trademark is a badge by which customers find your products or services in the marketplace. The owner of a trademark has exclusive use of that sign. Once in use, your trading reputation and goodwill will be attached to your business, making your trademark some of your most valuable assets. In effect, it is a symbol of trust. In the UK, a number of types of trademarks can be registered. To name a few, it could be a word mark, logo, shape, a position, pattern, color. It can be a single color. It could be a color combination, a sound, motion, multimedia, hologram. There are obviously more that keeps getting added to the list, and this is of course treated on a case-to-case basis. Generally in India and in the UK, prior to applying for a trademark registration, we always conduct a search. Now, this somehow seems to be a step that a lot of people or lawyers and clients want to skip to avoid the costs that are involved in conducting a search. However, personally and professionally, we would always recommend that a search has to be carried out. And if an applicant so wishes to file the application themselves, they would still have to carry out a search. And some of the reasons are very simple and straightforward. It is to make sure that you're not inadvertently infringing anybody's trademark, to see what is out there. You want to avoid your application from being opposed. Also, there are higher chances of success for the application progressing to registration. And generally, it is regarded as a good and sound legal advice that you would provide to your clients. In the UK, there are a number of things you would have to search if a client turns around to you and says, we are interested in filing a trademark. So what are those searches that we would carry out? First, we would look at the trademark register. This is actually, there is an online way of conducting the search. I've provided the link to the UK IPO search tool. You could generally search by trademark name, number, and owner information if you have it. However, if you're going to conduct a search to see what are prior registrations on the register, then you would ideally search using the word that you're interested in, and then you would choose specific classes, which would either be a classification of goods or classification of services. We also recommend that you must search the company's house records as well, in the event that you are treading on somebody's brand name. Because given that UK trademark law recognizes unregistered trademarks as well, this is something to bear in mind. The third search we recommend is to also look at domain names. One of the reasons why is because for the last decade, I would say that the having a website legitimizes your brand and your business. Given the number of smartphones that people use these days, the access to smartphones or the internet globally has pushed people to actually look up if your brand actually exists online. And the best way to do that is to actually register a domain. So if you're a brand that exists in India, ideally you would look at .co.in or a .com registration with your brand name in the second level domain, obviously. And then if you are in the UK or you're present in the US, you would probably look at registering .co.uk and .us, for example. So we also recommend that you should carry out a domain name search. However, these searches are not conclusive. Some of the reasons are, for example, the UK trademark register may not be up to date. An application that was filed 6 months ago may have registered, but the office has not updated. Therefore, when you look at it at certain points in time, you may not, it may come across that it's still pending, and therefore it gives you incorrect information to some extent, which is why we always recommend that a search has to be done very close to the time of filing an application. Generally, a search that is more than 2 months old is not a good position to take off from to file an application. Conduct a search again. I would say the maximum time one must allow is probably a month and nothing more than that. So if you've carried out a search a month prior to filing the application, this is still safe. It may still not be conclusive, but at least I don't think there'll be anything that could have come up within a month's time on the UK trademark register. Again, as I said, some searches are not conclusive because, for example, a well-known mark will not show up anywhere. But how do you take that into consideration? So we do something called a common law search. I did this in India as well while I worked. It's been now 8 years, but we still conducted a common law search in India. It is basically to look at the market, look at the specific business of the client, and carry out a search. It could be going to an actual physical market looking for products. These days, it's obviously far more easier. Most of it is available on the internet. So you would look at who owns what. Are they selling? Are they actually using their brand? And of course, there are companies like CompuMark who can assist greatly with a common law search. Nonetheless, always please remember that searches can never be conclusive because of the fast changing nature of the register, of the internet, and of course, brands coming up yesterday, day before, and a week ago, which may not have been covered in your search. So these are just things that you have to bear in mind, of course, when you carry out the searches. Now, another aspect of searching is if you're going to file an application in India, you have to search for prior marks in India, mainly because trademark law is territorial by nature. So if you conduct your search in India, then that is relevant only to the Indian application process or the registration process. If your client is interested to then apply in the UK, you would conduct specific searches on the UK register and in the UK as well. So the point I'm trying to make is a search is territorial by nature. Therefore, if your client is interested to file an application, the search has to be conducted in that particular country's jurisdiction first and foremost. When we carry out a search based on country alone, one of the things that a lot of lawyers actually miss out on is looking at the Wipo database. So Wipo is the World Intellectual Property Organization. They have a database where all the international trademark applications information can be found. I'm not very certain how many of you are aware of the Wipo system, which is mainly what we call as the Madrid Protocol system. But it is filing one application under the Madrid Protocol system, and then you designate a number of countries. And these applications are what we call as the international registration system. So you can actually find this on the Wipo database. I have provided some links again in my PPT, and you can have a look at that. Just carry out some searches, and you can see how the database looks like. So another aspect of searching, one must bear in mind to look at the Wipo database as well, simply because if you were to find an application on the Wipo database, once you make that application, you get 6 months, which is what we call as the convention priority, but I will explain that a bit more in detail in a couple of slides, actually. So those 6 months are given to an international registrant to then go and file applications in countries or member states who are members of the Paris Convention. So these are applications or marks that may not show up on the Indian search, for example, or the UK search. So just as a precautionary measure, I would also recommend that you carry out searches on the Wipo database. So I've spoken about what a search includes, and now we will move on to what it means to file a UK trademark application. Very quickly, again, like India, UK has a classification system under which you file your trademark applications. We have 45 classes. Class number 1 to 34 are specifically related to goods, and class numbers 35 to 45 are specifically related to services. You can file a UK application in 4 different ways, either online, fax, by paper, which is quite archaic, I think, but they have the opportunity to do that still and in person. Obviously, the paper aspect was suspended during the pandemic, but I'm sure that for applicants who prefer to file it, they would still print it off on paper, handwrite most of the information on the application, and then post it to the trademark office. I've also provided a link, so in case somebody's curious to see what the online filing process looks like. Of course, I can't show it here, but when you see the PPT, you can have a play around it. So generally, most clients, and in fact, I have never filed a paper application in the UK, but I did a lot of paper applications in India. In fact, what was a shame is after I relocated to the UK, then only we had an online filing program in India. So up until then, every single application that I worked on was actually a paper-based application in India. Obviously, here the preference is to file online. It's very quick, it's very fast. And also, the UK IPO encourages an online filing system because they give a discount on the official fees. So just as an example, if you were to file a paper application in the UK, for the first class, it costs £250 for each additional class, whereas the online filing fees is first class £170 and each additional class is £50. So this is just, again, it's fast and it's easy. Therefore, mostly everybody prefers to do the online filing. Of course, if an applicant is filing on their own, and if they don't know how to do it online or they don't have access to a computer, this is most likely when they would use the other forms, which is the fax paper, or actually go to the office and hand over your application. Also, an application in the UK, again, very similar to India, can be filed either by a legal representative or by the applicant themselves. In fact, very recently, I think maybe 3 months ago, the UK IPO has introduced a very interesting aspect in the online application form to cater to applicants who will file directly themselves without the help of a legal representative, a lawyer, a solicitor, and basically they have, of course, I can't explain it. You would have to try to go and look at the system yourself. But what it does is it actually talks them through the entire process, because as an applicant who's probably starting a new brand, they may not be aware of this process. So there is certainly more help from the UK IPO for applicants who are filing these applications on their own. It is mainly to assist them to ensure that they get the classifications correctly, because obviously that digs into the examiner's time to then go back to the applicant and explain it. Of course, they have also introduced, for example, if you were to upload a device mark which has both a sort of picture and words in it, their software is able to actually analyze the word or letters aspect in the device mark and then pull out that information. And of course, it will ask you to check if the letters in your device mark is actually correct. So they are bringing a very sort of robust system in terms of their online application process, which is of course very commendable. For legal representatives or someone with a trademark background, it may not prove that helpful, but I understand the approach of the UK Trademark Office and why they are trying to support applicants who would file this on their own. And also, of course, applicants, again, very similar to the Indian position, they have to be either natural or legal persons. So, for example, animals or cults cannot file a trademark application, generally because the idea is that a trademark is actually property. It is a type of intellectual property. So the applicant must be capable of owning property. I touched on this in the search topic about the Madrid Protocol, which is basically what we would call in general terms as international application. So the the UK is a member of the Madrid Protocol. India wasn't a member while I worked in India for a number of years. However, I think they became part of the Madrid Protocol somewhere post 2011. And now it basically means that you can file an international application at the Indian IPO and then designate the number of countries who are members to the Madrid Protocol. In the same way, UK has been a member of the Madrid Protocol for a number of years now. So they are an office, they have a department which deals specifically with only the Wipo applications. And of course, they charge a very minimum fee to process those applications. And it's just £40. But obviously, when you designate the countries, there will be a bigger fee that you have to pay. But this is just if anybody is curious to know what is the sort of handling fee. I can't remember what the handling fee at the Indian IPO is. But again, the handling fees will usually be quite subsidized because they are just acting as a postmaster to send the application for, they forward it to Wipo basically. So they probably charge some administrative fees at the end of the day. Also, something to bear in mind with the UK trademark system is UK is a member of the Paris Convention. So I spoke about this in the previous slide, again under searches, where we touched on priority claim. So let me, for anybody who doesn't know what this is, the Paris Convention is an international treaty which has a number of member countries who have signed up to this treaty. And one of the main, it has a number of aspects to it, but the most important one and the most relevant one to this webinar is that if you file a UK trademark application on today, 12th of April 2021, India is part of the Paris Convention. Within 6 months from the date of filing your UK application, you can then file your India trademark application, and you can claim the 12th of April 2021 as your filing date, because this is what the Paris Convention affords to the member states and applicants who belong to these member states. You get what we call a 6 months convention, priority convention. So in a way, effectively, you are filing a trademark application in the UK, and then let's say after 3 months, you file it in India, but you are claiming 12th of April 2021 as your filing date, even for your India trademark application. Now, one may think, why is this so convoluted? There is a great advantage on this because the trademark, both in UK and India, it is a simply first come, first serve basis in terms of application and registration. So if you were to file, if you were to take your UK application date, and let's assume somebody files a slightly or phonetically similar mark in India on the 19th of April 2021, your application supersedes them. Therefore, they cannot object to your application simply on that basis. So a lot of clients actually make use of the 6 months, and in fact, we advise strongly to clients who file a trademark application in the UK to consider this aspect. And if they plan to sell their product or launch their product in a variety of markets, we do strongly advise them to proceed and file in those respective jurisdictions by claiming that 6 months priority. So this is again something that the UK trademark system affords to applicants, is something to bear in mind when you are advising clients on the UK trademark process. And also another thing to remember with the priority claim is your first application, which is in this instance, the UK trademark application, need not have registered. It can still remain pending. And in fact, in India, when I did work in India, one of the things is the timeline for from application to registration is quite prolonged. I think the earliest I've seen an application register, at least in the time that I worked, there was around 24 months, that is close to 2 years. So you don't have to wait for your application to go through and actually get a registration certificate. The moment you apply, that 6-month priority clock will start ticking, and then you proceed and you go ahead and you file in all the member states, if you so wish, who are members of the Paris Convention. So that is another thing to bear in mind. So with the UK trademark, many people ask me this: what is the kind of timelines involved? I think because of Brexit, there is significant delay now in terms of processing the application up to the stage of examination. But prior to, I would say, beginning of last year, I have seen an application being filed, and it has probably registered within 4 months. Actually, that's the fastest I've seen an application register in the UK. I'm not saying that it is always the case, but that is quite possible in the UK. However, because of Brexit and the UK IPO being involved quite considerably, with handling a number of things due to the Brexit situation, at this point in time, we are seeing that it takes around 12 weeks for an examination report to be issued. Again, of course, quite similar in terms of the process of what a trademark application will go through up to registration, very similar to India and UK. If the examination report, sorry, excuse me. If there are no objections raised by the examiner, the application will proceed to publication. However, if there are objections raised by the examiner, we have to deal with that. And I will talk about some of the grounds that the examiners will raise and what they can raise in the next couple of slides. We will touch on that topic. However, if we assume that the examiner hasn't raised any objections, the application will get published. You have 2 months to oppose the application. Now, in the UK, again, a slightly different process to India. The 2 months opposition period can be extended by 1 month if one of the earlier trademark applicant or a third party will file a notice of threatened opposition. This is done by Form TM7A. There's no fee for this. And what it basically does is, the moment you file the threatened notice of opposition, the 2 months opposition period gets extended by a month. So in total, we would have 3 months from the date of publication. If we assume that nobody opposes your application, then the application hasn't been opposed. It will go immediately to registration. A registration certificate will be issued. Up until we went into a major lockdown last year, we were actually getting physical trademark certificates from the UK IPO. However, there was significant delay because of the pandemic, of course, and now they have stopped that process completely. They do not issue hard copy certificates. It is simply a soft copy certificate. In fact, the European Trademark Office stopped issuing hard copy certificates many, many years ago. So I think they are following that. It is quite simple and straightforward. You get it in an email, and it is it has the same value as that of a hard copy. I think the pandemic obviously put things in perspective for the UK IPO, and they decided, and they've changed their practice completely now. So the registration certificate is only an e-registration certificate, if we can call it that name. So generally, again, as I said, a smooth UK trademark application with no objections from the examiner, no oppositions by third parties, we are looking at a 4-month. So from application time date up to the issuing of registration certificate, which is quite quick and fast in my opinion. But sometimes things can get quite delayed depending on each application. Again, this is a case by case, but it is something good to know. So in effect, you could get a trademark registration certificate in the UK most likely in 6 months from date of application, which is quite quick, actually. Another aspect of the UK trademark law, which again, this is something that I have come to realize after working in the UK, is there is something called crown dependencies. They're basically 3 islands, which they're not part of the UK, but they are considered as crown dependencies. But they are self-governing possessions of the British Crown. One of the reasons why I want to talk about this is it is directly related to certain aspects of UK trademark law. So just to name the 3 crown dependencies, we have what is known as the bailiwicks of Jersey, bailiwicks of Guernsey, and Isle of Man. It is important for you to know about this, because when you are advising a client who is keen on selling a product in the UK and then they proceed to file an application in the UK, there are certain advantages that they could get from this from actually also registering in these crown dependencies. However, as an example, if you look at the bailiwicks of Jersey, which is a crown dependency, basically once you get a UK trademark registration, registration is automatic. So a UK trademark registration is recognized in Jersey, but you've got to do small little administrative things. You submit the official fee to the Jersey UK Trademark Office, and you file a certified copy of the UK registration, and you would then get actually protection in the bailiwicks of Jersey. It's a crown dependency, therefore you don't have to start the application process all the way, like as if it's a new application. But there are 2 requirements. You pay the official fee and you file a certified copy of the UK registration certificate, basically. Now, of course, Brexit will have an impact, and I will explain that in the last slide, so that I don't want to confuse the audience at this point in time. And then, of course, we have got another crown dependency, which is called the Isle of Man. Again, it's a very similar process. You pay the official fee, apply, submit a certified copy of the UK trademark registration certificate and your trademark, and you will actually get a trademark registration in the Isle of Man. And of course, you will you can then sell your products in the Isle of Man as well. A third crown dependency is what we call as Guernsey or bailiwicks of Guernsey. Now, Guernsey used to follow the same process as Jersey and Isle of Man. However, in 2006, they enacted what is known as the Trademarks Ordinance 2006. It basically means that they recognized the process what Jersey and Isle of Man recognizes, which is the official fee and certified copy system. Now, you no longer need a UK registration. They don't recognize a UK registration anymore. And therefore, you have to actually file an independent application in Guernsey. Again, the reason I have included this in today's topic is because a number of people will not consider that, for example, when you come into the UK and sell your product, if you were to sell your product in Isle of Man, it doesn't get automatic protection. As in, what I'm saying is you don't get an automatic registration, and therefore you have to take steps to actually protect your trademark in Jersey and Isle of Man following the process that I've just explained. Of course, with Guernsey, you would have to actually start an independent application there because it doesn't recognize the UK registration anymore. So these are just some nuances of the UK trademark system, which I thought might be quite interesting for our audience today to know about. Of course, again, I've provided some links if you wanted to go and read up a bit more about this aspect of crown dependencies. Now, while we talk about crown dependencies, it's also important to look at Gibraltar. Now, Gibraltar is right at the bottom of Spain. It is what we call as the British Overseas Territory and has no relationship to the UK as such. There is no control or anything like this. However, Gibraltar, being a British Overseas Territory, actually recognizes a UK trademark registration. I probably understand the confusion at this point from audience wondering, why is this important? Again, it's important because you have to understand how the UK trademark can be beneficial to your client. So tomorrow, if they say, well, we want to sell in EU or the European Union, Gibraltar is actually part of the European Union. And therefore, it would be good knowledge for you to have to then be able to advise your clients about Gibraltar. Essentially, a UK trademark registration is effective in Gibraltar. You pay the official fees, file a certified copy of the UK registration, and you have a registration that is recognized in Gibraltar. So in a way, a UK trademark registration technically can cover and protect your client's brand in the United Kingdom, Jersey, Isle of Man, and Gibraltar. So in a way, you're getting 4 different sort of territories with that one application which gets through to registration, for example. But of course, if you have any specific questions, I will answer those more in detail when we come to the end of this webinar. I will now briefly talk about some of the grounds of refusal by the examiner. So we discussed earlier the process of a UK trademark registration. So of course, the examiner has discretion to raise grounds of refusal. Again, what are those grounds, what can they raise, and what they can't raise? This is what we will look at now, but very briefly again. The examiner, so each application is assigned to an examiner, and they will look for certain basic filing requirements. First, have you written the applicant's name properly? Is the address correct? Specifically, if it's a UK address and they can't find it, they will write back to you and say, this address may not be correct, so please reconsider and provide us with the correct information. They will check that you've paid the right fees, and then they will also look at the classification aspect. However, there are 2 main grounds that the examiner will look at, apart from the filing requirements. One is relative grounds, the other is absolute grounds. So with relative grounds, they are basically looking for if there is an identical mark on the register with identical goods or services. Is there an identical trademark for similar goods or services? Is there a similar earlier trademark for identical or similar goods or services? And of course, the concept of likelihood of confusion will now kick in, because the examiner will wonder, well, if I allow this application to progress, is there going to be confusion from a customer's perspective with regards to an earlier trademark registration? However, in practice, the examiners generally do not raise relative grounds of objection when they are assessing an application. This is mainly because this is quite a Herculean task for them to do. Also, secondly, it is up to each trademark owner to protect his or her trademark and brand. Therefore, these are not aspects that the examiner will look at least not in the UK IPO. However, I have noticed that in India, we have a completely different practice. The examiner will raise objections on relative grounds, citing a whole list of trademarks that are already on the register. Those earlier registrations are a hindrance to your application being registered at the Indian IPO, and you have to overcome those objections. Essentially, remove classes of goods and services which are conflicting, or maybe it reaches a certain point where then you would have to appeal the examiner's objections because they don't accept your response to their examination grounds. So this I have seen quite consistently in India. There are pros and cons to that system. There are pros and cons to the UK system as well. And of course, I don't really want to comment because I have seen both the systems and they're there for a reason. Whether a lot of lawyers are quite disgruntled when examiners in India used to raise earlier trademark registrations because some of them haven't been used, and those could be challenged for revocation and cancellation proceedings, but it was not the examiner's responsibility to point that out. They were only doing their job, and they continue to do that. And again, like I said, both systems are different, and this is some aspects of which where the process is slightly different from India to the UK. So at the UK IPO, again, just to reiterate, an examiner will not raise will not raise relative grounds. It basically means the examiner will not tell a new applicant, by the way, there is already an earlier trademark registered. But what they will do is they will provide you with the list of all the earlier registrations, and they'll say, well, so this is an examination report. I have found earlier trademark registrations, which I think are very similar to yours. Please reconsider if you want to cut down some of your classes. So they will make a suggestion, but it is never something that they will raise actually as a ground of objection in the examination report. However, what they will raise, and which we have seen more consistently in the UK, is they will raise absolute grounds of objection. It's basically if a trademark is descriptive, it's devoid of any distinctive character, it's too generic, it basically it fails to exist as a trademark, and therefore we call that as absolute grounds. This is where the examiners will actually really are very strict. They do, if a trademark doesn't satisfy those requirements, they do raise them under the absolute grounds. Now, another thing which I have seen in my experience, a number of things or objections that the examiner comes up with is the classification aspect. So certain terms do not fit under this class. They will point that out to you. I wouldn't say that that is an objection in any way, but they're inviting you to revisit those terms, what you have used to describe your goods and services, and then they will afford you the opportunity. So for example, if like coffee and tea, you have classified it incorrectly, they will tell you, please reclassify that under class 29. And then, of course, because it's a new class that you will add to your application, you have to pay the additional fee, and they will allow you to pay that, because generally what the rule is, once you make an application, you cannot then go back and change the classes or the number of classes, which is why we constantly check with clients, please ensure that you are protecting everything in this particular application. However, when the examiner raises the issue of classification, you are always given the opportunity to basically add a new class if the examiner allows it. So this is completely at the discretion of the examiner. We can't take this as a guarantee that they would allow it. Sometimes they may just turn around and say, actually, we are not going to allow this term. Please delete it from the classification, and then it will proceed to publication. Again, with an examination report, no matter what the grounds are, so if the examiner raises grounds on classification, or they raise the absolute grounds issue, you always only get 2 months' time to respond to the examiner. Generally, we cannot get extension of time. We can make a request to the examiner citing certain reasons, which has to be very substantial. Therefore, it is extremely important that when we get an examination report from the UK IPO, we inform the client immediately, seek their instructions, and then proceed to filing a response if it so requires. Because getting extension of time to respond to an examiner's report is quite difficult. And that is, again, something that slightly differs for us from India and the UK. In India, we do have option to seek extension. In the UK, the extension of time is mainly at the discretion of the examiner. So this is just something to bear in mind when, when you receive an examination report, for example. And of course, the other option is, let's say that the examiner raised a ground of refusal on absolute grounds, but only on a particular classification of goods. So you have filed an application for shoes, to protect shoes, and I don't know, pressure cookers, for example. Obviously, the examiner will object to shoes being protected for shoes, because that is a very generic word. It describes what your mark is. But the word shoes is not descriptive for pressure cookers. So they will allow that. So therefore, sometimes what we tend to do is we will divide the application at this time, which is again allowed at the UK IPO. In fact, that this is another process that is available even at the Indian IPO. So what basically happens at this time is, because the examiner has objected to one class, you divide the application to the unobjected class so that that can proceed to publication. And then you deal with the objected class, try to convince the examiner with your response how shoes can be a good trademark for shoes. And of course, if they're not convinced, they will reject those the response you file at the end of the day. However, it just means that you don't lose the entire application. The part of your, like maybe half of your application, can now proceed to registration. The other half, which has been objected, will basically just be a rejected application, because the examiner doesn't allow it to progress any further. So again, this is something, it's not unique to the UK trademark system, but it is just something to bear in mind, I would say, when you are looking at some nuances of the UK trademark system. Because we've spoken about relative grounds and absolute grounds which an examiner can raise, I will now talk a little bit about grounds of opposition. So this is mainly when an application is published. What are the kind of grounds under which a party, an earlier trademark owner, or a third party can raise to object that application from progressing to a registration? Now, grounds of opposition, what we have under the UK Trademark Act, is exactly similar, in fact, identical to how we follow in India. So there isn't much difference in the theoretical concept of the grounds of objection, but of course, there is a lot of difference in the procedural aspects of opposing an application. You may recollect that I mentioned that we have an option to file a notice of threatened opposition in the UK. This is mainly done to put the applicant on notice that actually we are interested to oppose your application. It can, it may to a certain extent allow these interested parties to talk to each other. And the UK IPO is more inclined that the parties try and come to a settlement rather than fight it out. Because in general, here of course, not just here, throughout the world, litigation should be the last resort. If parties can negotiate, then that should be your first go-to option, not litigation. So filing the notice of threatened opposition is mainly meant for this. Of course, to preserve the rights of your client, you would still file an opposition notice eventually, even though you get that 1 month extension. However, and I'll come to that in a few minutes probably, and I'll talk to you about what this particular procedural aspect is where you can tell the UK IPO, actually, we are both trying to negotiate. So we want you to, we want to enter into a cooling off period. I will explain that in a bit more detail. So just coming back to the grounds of opposition, now the relative grounds and the absolute grounds are again similar grounds on which you can oppose a trademark application. Just looking at it very briefly, an earlier trademark owner of a registered trademark can oppose on 3 different grounds. It can be all of them, it can be just one of them. That theirs is an identical earlier trademark with identical goods or services. In short, we call this as double identity. That the earlier trademark is identical for similar goods or services. And the third ground is similar to an earlier trademark for identical or similar goods or services. Again, the form that is used to file the notice of opposition is quite detailed. It is also quite complex, and therefore it is divided. The form is actually divided. So if you are going to file, let's say on the 3 grounds that I've just mentioned, the double identity, identical earlier trademark for similar goods, similar earlier trademark for identical or similar goods or services, you would use a certain aspect of that form. I don't want to confuse matters, but this is one of the complex aspects of filing a notice of opposition in the UK, which I myself, of course, I was unaware of it. And once you start doing them, you become more aware, and then of course it becomes very easy to understand the form. But one of the reasons why they have the form and why it is subdivided based on the type of ground that you wish to oppose or rely on, it's basically to make the decision, it's basically to assist the decision maker better. So, for example, before the Indian IPO, we would simply file notice of opposition and all of our grounds providing a statement, etc., etc. However, sometimes, because this can run into a number of pages, the decision maker may not be actually able to identify exactly what grounds you're relying on, and they may need further clarity. So this is, of course, my way of looking at it, because I have something to compare it to, considering I worked in India and I'm now working in the UK. The notice of opposition form is very detailed and very strict. There's a very strict criteria under which you can file it. And therefore, they have made it strict because it's mainly for purposes of clarity. So if you were going to file on a certain ground or rely on a certain ground, there is only particular aspect of the form that you need to use. And of course, the more you use it, the more familiar you become with it. So I will move on to the next ground of opposition. Again, all of these grounds are listed under section 5. Once you see the PPT, you will see I have broken it down section wise, and it's probably more easier to follow when you're looking at the PPT anyway. So the next ground that an earlier trademark registrant can oppose is if the new application or new trademark is taking unfair advantage of, or it's being detrimental to the distinctive character or reputation of an earlier trademark application or registration. This is what we call as well-known marks. So sometimes a well-known mark can be registered, and it need not be registered because the UK trademark law recognizes and gives rights to unregistered trademarks as well. So actually, you don't have to have a registration to oppose somebody's application as long as you satisfy the criteria that is required. And Section 5 subclause 4 allows you to actually oppose based on your mark being a well-known mark, and it's either registered or it's not registered. So you have this option as well. And then, of course, there is section 5(4) subclause A, which then goes into talking specifically about unregistered marks. So this is mainly for any trademark that has never been registered, because again, because of the common law system, we also have this option in India, by the way, where an unregistered trademark, an unregistered mark, the owner of an unregistered mark can actually oppose a trademark application because it conflicts with the unregistered trademark or other sign, because the reputation and goodwill have been acquired prior to the date of application of that trademark application that has been filed. Obviously, there is a lot of criteria one needs to satisfy, a lot of evidence one has to file. But the fact that the UK IPO and the Indian IPO actually afford unregistered marks that right to oppose somebody is actually fantastic, because in civil law jurisdiction, we may not have this opportunity. So it is again unique to the UK trademark system, unique to India trademark system, and it is very good because it accommodates unregistered trademarks as well. And the last ground on which one can oppose is completely listed under Section 3. This is the absolute grounds that we just touched on. So, for example, a trademark that is descriptive, it's devoid of any distinctive character, it's too generic, it's a general expression used in trade or profession or the business. And then to add a couple of more to that particular list is that it's deceptive. It basically gives a false impression as to the type of quality of the goods or services. And lastly, it's contrary to public policy or to accepted principles of morality. Now, these grounds can be raised when also you have to prove, as the person opposing on these grounds or relying on these grounds, that the application was made in bad faith, one. And two, you need not be an earlier trademark owner to actually oppose an application on these grounds. Anybody in the whole wide world can oppose this. Obviously, the criteria is very strict. Therefore, you must be able to satisfy the examiner why you believe that this was made in bad faith, is devoid of distinctive character, etc., etc. But these grounds, what we categorize as absolute grounds, is actually open to anyone, and they can actually oppose your application on these grounds. Whereas the previous three grounds that we discussed, which are mainly relative grounds, the well-known marks, the double identity, and the unregistered trademark proprietor opposing the application, those can only be opposed by an actual trademark owner, not the licensees, not the sub-licensees, not the assignees. The actual trademark owner has to oppose that. Whereas with the last set of grounds, where we're talking of devoid of distinctiveness, descriptive, and too generic, anybody can oppose under the absolute grounds. Generally, what I have seen from my experience is that it can take anywhere between 8 to 12 months if opposition proceedings start. It is fairly quick and smooth, and even if you don't have legal representation, we have seen, the UK IPO will not provide any advice, but they will tell the opposite party, for example, if they're a party in person, they don't have a lawyer representing, they will tell them what aspect of the trademark manual to read. But that is all they will do. But there is some assistance given to such applicants or party in person applicants for that matter. Now, I briefly touched on something called cooling off period. Again, this is something interesting about the UK opposition proceedings. If the parties who have initiated, if somebody has opposed your trademark application, and you start negotiations, and you don't want the burden of the office setting a structure for the opposition proceeding. So for example, there is a series of things that will happen. You will file your notice of opposition. The applicant will then file their grounds in response to that. So basically, and then after that, the UK IPO will say, well, you've got this much time to file your evidence. The other side files. So they will clearly structure, there will be a timeline for the opposition proceedings. Now, some parties who are negotiating, they feel that we don't want the burden of this because we are actually getting very close to negotiating and coming to a settlement agreement. So what they can do is they can enter into what is known as a cooling off period. So one of the parties will request for this. The initial cooling off period is 9 months, and it can be extended by another 9 months. But the second extension can only be done at the request of both parties. This is mainly, this is very different from suspending an opposition proceeding. So please don't confuse this aspect to that. They're two very different things. Cooling off period is mainly to tell the UK IPO, we are entering into negotiations. We don't want the burden of having to file evidence and things like this. So please allow us 9 months time to come to terms with what we want to negotiate, how we want to settle this matter. Now, let us say in amongst this negotiation, you have got the cooling off period, you are in the cooling off period, but you have not been able to come to any agreeable terms. Either party can write to the UK IPO case hearing officer and say to them, we are not able to, we are not able to settle any terms. The negotiations have fallen off. They've fallen through. We are unable to negotiate any further. We want to come out of the cooling off period. The moment one of the parties say this, the decision maker is bound to lift the cooling off period. As soon as they lift, they will then set a timeline, like as if the loss of time never really happened. Let's say it took 6 months and you didn't conclude anything between yourselves and the other party. It's almost like as if those 6 months have just been forgotten. They will now set timelines as to when you have to file your evidence, when the applicant has to file evidence, and then the opposition proceedings will now become live. Basically, that is what it means. This is again another sort of nuance of the UK trademark system, I would say. And of course, let us assume that the parties conclude. That is a fantastic thing. The decision makers or the case officers are very inclined to give an extension on that cooling off period. They generally they generally don't oppose, because they are more inclined that parties should negotiate. It saves a lot of time and costs for both parties, because at the end of the day, if you're not able to enter negotiations, if you were to come back and actually fight and go through this opposition proceeding, it means that the party who loses at the hearing will have to pay costs to the other side. So they bear this in mind, given the expensive nature of the opposition proceedings itself. There is more inclination to, say yes to the request for cooling off period. Now, obviously, again, this has to be looked from a case-to-case basis. I don't want to comment any further, because sometimes cooling off periods are entered into and sometimes they're not entered into, and that is basically litigation strategy, and that will entirely depend on each case. But this is something to bear in mind, that this is an aspect of opposition proceedings that is very unique to the UK, actually. The EU, the European Union, also has quite a similar process, but their cooling off period is significantly longer. It is, I think, 21 or 22 months, and another extension can be sought for another 21 or 22 months. So I'm guessing theirs is far more protracted than the UK. But coming back to the opposition proceedings, generally, if neither party enters into a cooling off period and the opposition proceedings were to go ahead, we have seen that it takes anywhere between 8 to 12 months. Parties can request hearing. During the pandemic, they were all done over the phone and through video conferences. But prior to that, The hearings did take place at they have a London office because the UK IPO main office is actually in Newport in Wales, I think, which is quite further up north in the UK. But the hearing actually takes place in the London office. And sometimes if the case officer sits at the Newport office, it would just be a video conference for both parties. So all the three parties would basically be in a video conference, and that is how they would conduct the hearing. Of course, the pandemic meant everything has now become video conference, and we are still waiting to hear when the offices will reopen and whether hearings will actually take place face to face. Nobody knows what will happen here in the UK at this point in time. Of course, with the opposition proceedings itself, a case officer is appointed. They're usually somebody who has great experience in opposition proceedings, a little bit more senior than just an examiner, for example. And then once the case officer issues the opposition decision, the party who is not happy with that decision can appeal from the opposition decision to an appointed person. Usually an appointed person, they are experienced trademark practitioners. They are mainly appointed by the UK IPO to hear the appeals. Of course, if there is a conflict of interest, they should not hear such matters, but generally these things are very carefully looked at before an appeal from opposition decision is assigned to an appointed person. Again, the UK IPO has a list of all the appointed persons who have been working with the UK IPO for a number of years. All this information is, of course, public, and I have also provided some links to the opposition proceedings before the before the UK IPO. And if anybody is interested, you can have a read through the proceedings and the manual. Of course, it's a very interesting read. So I would encourage you all to read it if you have the time to go through that, actually. So of course the opposition proceedings are very unique in the sense that not everybody who files a notice of threatened opposition will actually see that through. It is actually quite significantly less compared to India, for example, where I have seen more applications being opposed by earlier trademark owners. Again, not sure what the reason is for that. Are they more conscious to protect their brands? Are people here less conscious to protect their brands? I don't really have an answer to that, but maybe brands in India are far more aggressive to a certain extent. I mean, I have seen that with certain clients who handle a very big portfolio here in UK. Brands are very strong, and then therefore, the filing oppositions against new applications is also quite aggressive. But however, generally, the amount of cases that go through the entire opposition proceedings is far lesser, I would say, compared to India. Mainly, I think one of the reasons mainly is because of the number of applications that are filed in India. We have to, at this point, remember that India has around 6 trademark offices. A huge number of trademark applications are filed, as opposed to the UK, who have 1 trademark office. The country is really small, and if you look at if you were to compare statistics and the number of applications filed, the UK IPO receives probably 1/10 of what the Indian IPO would receive in terms of trademark applications. So this could be mainly the reason, I would say. But of course, going back to the registration process itself, I hope that the opposition proceedings, even though it's very brief, it has given everyone a little bit insight into how things are conducted into the UK. We cannot go too in detail in terms of the grounds of opposition itself. It would be quite good probably to have that as a separate session maybe in the future. But yeah, so for now, I hope that the opposition proceedings at the UK IPO has given some insight, and I will proceed to the last aspect of the trademark process itself, which is the registration aspect. So, of course, as I mentioned earlier, the UK IPO now issues only an e-trademark registration certificate. It is as valid as the hard copy certificate. I cannot remember if the Indian IPO has moved on to an e-certificate yet, but I think that will be the future, or rather, this is the future of trademark certificates becoming e-certificates rather than hard copy. They're easier to maintain. And generally, if you need a certified copy, you still have to make application to the whether it's the UK IPO or Indian IPO, the process is the same. So the UK trademark registration is valid for 10 years. Once you receive a certificate, that registration is valid for 10 years. You have an exclusive right to use your mark. You can now use the R in a circle symbol. Also, one thing to remember on this point, is that if you were to use the R symbol before your trademark has actually officially registered, that is considered as an illegal action by an owner. So what we always recommend is the moment you file a trademark application, a UK trademark application, you could use the words TM in the corner of your brand. It then means that you are trying to educate your buyers or your customers and the world in general that that is a trademark that you wish to use. And then, of course, once you have the registration, you use the R in a circle symbol. What are the advantages of registration? It is easier to take legal action against third-party infringers. This is where the cons of unregistered trademarks kicks in, because with an unregistered trademark, you have to file quite a bit of evidence to show proof that you actually own the brand. However, having a trademark certificate, a registration certificate, is proof that you have a registration for your brand, and the goods and services or the classification of goods and services will tell somebody what your brand is registered for. So it makes the process of taking legal action against infringers a bit more easier. Also, a registration means it can put off third parties from using your trademark, because the moment they see that you're using an R symbol, it has a psychological effect. And this is one of the reasons why it's important to get a trademark registration. The moment they see that, there is something in their mind that it makes them think, should we be infringing on this person's trademark? That R symbol has become quite universal. Most people, even if they don't know what the trademark or what a trademark or what trademark law is, generally they identify the R in a circle as a registration. So it is good that you have this for your mark. You protect your brand essentially, and it is sort of putting everybody else and the rest of the world on notice to say to them, well, yeah, I have a registration, and therefore be aware not to infringe on my rights. Of course, in the same way, it is easier to take action against counterfeiters. It's the same situation both in India and the UK. Counterfeiting market is very rampant and significant. In India, I have worked on a number of counterfeiting cases where we'd had to go to the High Court and get directions to actually lock down the factory. And of course, in the UK, the counterfeit market is mainly with the luxury product market, like a Louis Vuitton bag or a Burberry like a Burberry suit that is being counterfeited. It is extremely difficult, but with the right sort of legal action, with the right steps that brand owners can take. And of course, one of that aspect is the fact that they have registered trademarks, makes the whole process far more easier and achievable to stop third parties from counterfeiting your products. And lastly, of course, registration means as a trademark owner, you are now in a very good position to sell your brand, given that many of us, or maybe some of us, have already done a lot of work on IP due diligence. We know that goodwill, and when we look at due diligence specifically, that brand names are actually quite highly rated in terms of the money aspect. So when we look at it from a financial perspective, a brand costs a lot to make. And when you sell that brand, you earn a lot of money from that sale. So as a trademark owner, technically, you have put yourself in a very good position to sell your mark if that is something that you wish to do, or you franchise your mark, or you license your mark. I don't think you can still do all of these with unregistered marks, but you are exposing yourself to quite significant risks when you do that without registrations. And this is one of the reasons why we always constantly and consistently advise clients, make sure that you have registrations, make sure you make those applications, file those applications. We push very hard with that, because there are certain things that makes it so much easier in terms of the process. A franchise, for example, or a license, for example, it is easier to refer to a registered mark, look at its goodwill, do a due diligence, etc., as opposed to looking at an unregistered mark. And I won't go into the details of the difficulties with it, but on the face of it, it is easier if you were to have a registration. Now, another aspect of trademarks, and this is not just unique to the UK, in fact, a lot of jurisdictions require this from a trademark owner. Simply because you have a trademark, it doesn't mean that there is no responsibility on the owner. So as much as the Trademark Act gives you certain rights, it also expects something from a registered owner in return. And basically what it is it tells the trademark owner, once you have got your registration, you have to ensure that you use your trademark, and you have to put that trademark to genuine use. Because there are a lot of applicants out there who will go and register trademarks that they may never use. And this is what we call as the non-use provisions under the Act. This is, again, something both India and UK have. The non-use period, again, both in India and UK, is 5 years. There has to be a genuine commercial use. Of course, what is genuine commercial use is decided and varies from case to case. But the idea is you don't get a registration and then never use that mark. Because what would happen and what will happen, we have seen this a number of times, is somebody who doesn't use their brand or their mark that has been registered will fall foul of what we call as a revocation proceeding. Given that the non-use period in both India and UK is 5 years, it is calculated from the date of registration, because the date of application and date of registration are two different dates. So when you're calculating the non-use period, you are looking from date of registration, from there onwards 5 years. If you haven't used your mark, anybody, any third party, they need not have any relationship to your mark. They may not have any interest in your trademark, but as a matter of right, anybody in this world can actually file a revocation application before the Indian IPO and here the UK IPO, and actually tell the office, by the way, they haven't used their trademark. There is no genuine commercial use. Please remove this trademark from the register. Now, this is done for a number of reasons. If somebody sees that they want that brand and you haven't used it, they are in their right to raise that as an issue. Again, another aspect where the non-use issue comes up is when we look at somebody who has opposed our trademark at the time of publication. We can then question, have you used your trademark? And then it's sort of, again, it's litigation strategy. Because they have opposed your mark, you are then putting them on notice saying, well, actually, since you're opposing your mark, have you actually used your own trademark? Show me genuine commercial use. If they can't show genuine commercial use, you will then go ahead and file a revocation application against their registered trademark. Technically, in a way, you are protecting yourself so that your application doesn't get hurt. And it is also a very good ground that a number of applicants do use to counter, sort of, I won't say it's a counter statement, but yes, if we were to just take that word at this point in time, in their counter statement, they would file. That is one of the grounds. And generally, the case officer will then ask the trademark applicant, yes, your trademark has been registered more than 5 years ago. Please provide proof of genuine commercial use. So it is very important to know that as much as you get a number of rights from a registered trademark, the onus is on the trademark owner to ensure that they actually genuinely put the mark to commercial use. Otherwise, we are clogging up the trademark register with marks that are never going to be commercially ever used. In a way, you are hindering other people from using those marks. So this is mainly a public policy issue. So it's just something to bear in mind when you, again, I've provided some links and you can have a read through those sort of aspects of the non-use in the UK trademark system as well. Of course, a trademark, again, it is a renewable right. So unlike patents, where we have it for a certain number of years, and then the right expires, a trademark is what we would call as an infinite right, because as long as you renew it, you can own a registered trademark for how many ever number of years, 100 years, 200 years, as long as it is renewed. So what does the UK trademark, and how would you renew a UK trademark? So we looked at the registration aspect. It is 10 years protection that you get, 6 months prior to the date of renewal, and up to 6 months after your date of renewal, you can renew a trademark. If you do it prior to 6 months, there is only a certain set of official fee. It is £200 for the first class and 50 for each additional class to renew a trademark. If you were to exercise your renewal rights after the expiry date and up to within 6 months, there is a small sort of late renewal fee that is charged by the UK IPO. Now, the moment the 6 months after your date of renewal has expired, there is no way you can restore the trademark. That is why making sure that you are keeping track of renewal dates for your trademarks is extremely essential. Generally, a lot of firms in the UK and India use IP databases for this. The deadlines come up automatically on those databases, and the administrative staff, and in the UK, the paralegals will generally be involved in ensuring that renewals are done on time, the fees are paid on time, and to basically ensure that the client doesn't lose their trademark rights. However, there is one way you can restore the trademark, but it is not a guarantee by any means. There is a form that you can file before the UK IPO, and this can only be done by post. So let's assume you have surpassed the 6 months post your renewal deadline. There is something called restoration of the trademark. You are meant to provide a written statement explaining why you couldn't carry out the renewal. Again, this is a discretionary right of the UK IPO. The form itself, there is a fee for the form, it's £100. There is no guarantee that the UK IPO will actually restore your trademark application, but there is an option to make this application, And if the UK IPO is satisfied with that written statement by the applicant, basically it will be like a written statement of the applicant that the lawyer will file on their behalf, explaining why the renewal wasn't done. And then it's entirely up to the UK IPO to actually even consider that. But of course, one of the downside is the fee that you pay for the restoration is non-refundable. So if the application is refused, you do not receive that fee back. So of course, you have to bear in mind this aspect as well. For an applicant who has a very valid reason, it may be that their trademark application does get restored. So this is sort of the last resort. And once that application for restoration is rejected or refused by the UK IPO, there is no appeal from that rejection or the refusal. And therefore, technically, you have lost the registration of your trademark at that point in time. So we are almost coming towards the end of the this webinar today, and an important aspect that I want to talk to everybody about is Brexit. Brexit has had a significant impact on the UK trademark system, but certain things only I can cover today because anything else would probably go into too much detail. So I have noted around 4 issues that is very important for our audience today to learn about what Brexit and how Brexit has impacted the UK trademark system. So as you're all aware, UK officially left the EU, the European Union, on the 31st of December 2020. As of now, there are only 27 member states of the European Union. The European Union has a trademark system called the European Union Trademark. Earlier, it was known as the Community Trademark, in short CTM. Eventually, it was renamed as the European Union Trademark, which we call in short as EUTM. So you have the UKTM and the EUTM. So one of the advantages of the EUTM system was an applicant would make an application to the European Union Intellectual Property Office, one application to cover 28 member states. This was one of the advantages afforded to trademark applicants who were interested in filing an EUTM. At the time of filing, and because UK was a part of the European Union, UK was also a territory that was protected under this EUTM application. What that basically means is you have made an EUTM application, it goes through registration, you can sell your product in all the 28 member states. You are protected by law in all the 28 member states. Now, because UK left the European Union and the hard deadline was the 31st of December 2020, what does it mean for somebody who has filed an application and has a registered European Union trademark application? Because that actually already covered the UK. Does it mean that they have been given protection, or do they continue to have protection? So these were a lot of questions that were debated by the Parliament. A lot of trade talks happened, and this is what has now been concluded. So if you have a registered EUTM or a European Union trademark, which was registered prior to the 31st of December 2020, the UK IPO will create what is known as a comparable UK right. What that means is the EU trademark application will be copied onto the UK trademark register. The original filing date is retained. There is no fee because this is something that the UK and the EU have agreed between themselves. All of the filing dates, any priority dates will all be retained. It is almost as if the EU trademark has been replicated onto the UK register. because the applicants or the trademark owners should not be penalized because the UK left the EU. This was a sort of way to lend their hand to trademark registered owners of EUTMs. However, there will be no UK registration certificate that will be issued. It will simply be copied onto the UK Trademark Register. Of course, the other advantage is you now have an independent UK trademark that can be challenged, assigned, licensed, or renewed separately. So once you have a comparable UK right, what happens to your original EU trademark registration? It remains as is, as long as you renew it, which again for the EUTM is 10 years, very similar to the UK. But what it means in theory is now the protection of your EUTM is only now limited to 27 member states and not 28 member states, since the UK left the EU. So in effect, you have one EUTM and one UKTM. Also, you have to renew both of these trademarks at the time they fall due. If you fail to renew your UK trademark, the comparable UK trademark, you will lose the rights in this mark. However, if you decide, well, I'm only going to renew my EU trademark and not the UK trademark, then that is entirely up to you to do so. But what I'm trying to say is, because you already had a EU registration, they are providing a comparable UK right, but the renewals have to remain separate. So you have to renew your UK comparable trademark, and then you have to also renew your EU trademark. I'm not very sure whether this point is more confusing, but hopefully if you have any questions, you can ask me towards the end of this webinar, because I understand this is a bit more complicated, and if you haven't dealt with UK and EU trademarks, it's a very difficult concept to grasp. But then again, there's a lot of reading material out there, and if required, I can share some links specifically to the Brexit situation again. And then, of course, a number of applicants filed EU trademark applications last year. So let's assume they're all pending and they haven't registered at the date of 31st December 2020. So what happens to those pending EU trademark applications? The UK and EU have again come to an agreement that those applicants will have up to the 30th of September 2021 to actually make an application so that they can gain a comparable right. Because at the time when they filed the EU trademark application, UK was a member state and they would not have filed a separate UK application. So this is basically to not penalize applicants who believed that at the time of making an EUTM application, UK would have been part of that application. So this is mainly not to penalize them, to afford them the opportunity to get a UK comparable right. The UK and EU decided that this is something that we can offer applicants. So they have up to 30th of September 2021 to, so with the pending trademark applications at the EU, they have to physically file. So how I was talking about the online application and the where you make it either via paper, fax, or online. So they would actually have to file an application. In the application, you have options now where it asks you, are you actually filing because you have an existing EU trademark application which is pending? You would tick yes. And that is how the UK IPO knows, oh, actually, this applicant is filing based on a pending EU trademark application. You will have to pay fees to the UK IPO, which is the official filing fees. Only the applications has to be identical. You cannot file a completely different specification. You cannot file for a new mark. Anything you're going to rely on has to be based directly on the pending EU trademark application. then it will go through the same process as if you have filed a national application. The application is examined by an examiner. If there are objections, they raise the objections, and then it proceeds to publication, and then a registration certificate is issued. So because the process is slightly different for a registered trademark and a pending EU trademark. Of course, please feel free to ask questions on this particular aspect, and I'm happy to clarify. Again, we have not discussed community designs or registered community designs at all, but just I want to raise this point because I know many of you may have already dealt with design applications in India and outside of India. So the same process as I explained for the registered EUTM and the pending EUTM applies to design applications. So if they are registered community designs, they will get a comparable UK design. If they are a pending community design, they will then have to make an application based on the pending community design to get or to achieve the comparable UK design. And again, the deadline for that is the 30th of September, 2021. So, of course, the UK register is slowly being updated. And therefore, you will now start to see a lot of EU trademark comparables that are coming onto the register. Usually, they start with UK 009 and then the numbers. And I think with the international registrations, which designated the EU, are also going to come on the UK register. And I think they start with UK 008 and then the number of the international application. So I think with Brexit, we have come to the end of the webinar from my end. Of course, if Abhishek has already received any questions from the audience, I'll be happy to answer them now, Abhishek.
Sure. Thank you for such a detailed discussion, Ramya. Now we can take up the questions. So far we don't have a lot of questions. We can wait and see if anyone has questions. Meanwhile, I happen to have a few questions basis basis what you said. So we talked about common law search as well, wherein which would essentially include the trademarks which have not been registered. Uh, is that the correct understanding? So how would one conduct a search for those trademarks essentially? Because there would be no, like, they won't be present in the database. So
correct.
Yeah, how would that be dealt with?
This is a very, very good question. In fact, common law searches are very complicated. And in fact, a lot of lawyers, even with a number of years of experience, they tear their hair apart when it comes to common law searches because we have nothing to rely on. The mainly, I think these days, and this is the power of internet, of course, I think 20 years ago in India, we would have been unable to conduct that unless we physically went into a market, as I was explaining, which I have seen people doing it because that was the nature of things then. So with the common law search, there are two ways of doing it. One is to scout the internet, look at a variety of search engines, look at a number of social media platforms, but you still may not have a conclusive answer to that common law search, but you have exhausted all the options. The second way to do a common law search, which is not something that we would do ourselves, is actually, so we've got, for example, we've got CompuMark. It's a company who does very detailed search reports, and it is something that we have used. We do use in different practices here in the UK. I am not very sure whether it is very prominently used in India, but there are companies who can assist with a common law search. Now, again, is that conclusive? Probably not, but they use very high-end algorithmic softwares, which is scouting the internet at crazy speeds. To a certain extent, that is reliable, but I would always, write a disclaimer explaining to the client how sometimes this cannot be conclusive, but actually we've done a pretty good detailed search. And of course, for example, I was mentioning the company names, the company's names register in the UK. We have done that in India as well. I would still recommend anybody doing a search in India to look at company names tribunal, look at NICSI, look at the domain names searches, go to the there is a search tool specifically to look at domains, and it will pull up a list of domains and who is registered. I mean, these days we can't see the registrant details anymore because of data privacy laws, and it's all hidden behind the registrar's details. But at least that has been registered. Is it a live domain? Those are the kind of common law searches one can do. But again, it may not be conclusive. And it is, again, something one has to think on their feet, depending on the brand as well. So if it's a shoe brand, what are the kind of social media platforms one can scout? These are, again, search strategies can vary depending on the brand you're searching for. If it's a tech brand, then your search strategy will change completely. So yeah, it's a great question, Abhishek. But I don't know if I have answered your
No,
question effectively or
yes,
no.
yes. You've definitely answered my question. So I've understood that there is no short way to just conduct this search, but there are definitely mechanisms. Like, this is a
Oh
really
yeah,
great idea that you can go through databases which just provide government databases, in fact, which just provide company names. So, for example, in India, there's the Ministry of Commerce website.
yes,
They have the entire list of all the startups that have come up recently. So you
right,
can definitely go through them as well and see if
correct,
someone is using a similar name. So
absolutely,
I think this could be, in fact, pretty interesting to conduct, although not a very comprehensive way, but
yeah,
like, such ways can definitely be applied to conduct a common law search. So this is really
absolutely,
interesting.
yeah,
Um,
absolutely,
Yes. So regarding, okay, so this is not pertaining to UK law, but since we did discuss the Madrid Protocol application as well, I
yeah,
was just wondering if, so for example, like you said, that somebody has registered a trademark in, for example, UK some time ago, and then there a priority application comes into picture. So
mhm,
now they will not be the the person who registered the file for the application prior to this person in UK. They will
correct.
not be able to oppose
Stop,
the application, right?
exactly.
But but what about the person who has come later on through Madrid application? Can they do something about the application that is already?
Yeah, if that is, yeah, of course, because all applicants don't oppose, because one is, it's a very time consuming
Mhm.
and an expensive affair. They have to see, do we have the budget to do this? Because once you oppose somebody, you have to be ready to face the consequences of that. And this is where we were talking about the non-use, because you will get challenged on those grounds and you have to be able to show. So in this instance, if the international application applicant has decided, I will let this go, they have let it go. However, sometimes, again, this is my experience from India more specifically rather than UK. We did have certain clients, because of budget reasons, or they didn't get the go ahead from their internal teams, couldn't oppose an application. And then once it's registered, we would then go ahead to cancel the application.
Okay.
So again, that is a strategy. Is it good to do that? No, but sometimes you are faced with situations, because clients, because every client is different. A client doesn't have the budget, so they'll say, well, Ramya, I can't oppose it now, but let's think about it in 2 years. And in India, given how long it takes for a trademark to register, maybe that is an option to consider for them. Ideally, we would like them to oppose it at the stage of publication, because that is the really it's like hitting the iron when it's hot. It's really the best time to oppose, but sometimes things are beyond a client's control and therefore they can't oppose the application. And I've seen that even in the UK, they have missed a deadline. Again, because in the UK, the timelines are so strict. You don't file your notice of threatened opposition. You cannot file a notice of opposition. You have missed that. And that is gone. And therefore, they have to reconsider strategy as a matter of fact. And then therefore, they have to ask themselves, well, we've missed this deadline. So now we are going to wait and try to, cancel this application, which is a completely different proceeding altogether. Yeah.
Got it. I understand. So this is basically more of a shortcoming, I would say, with respect to the Madrid Protocol, because this is kind of unfair to the applicant who has like domestically filed an application, but they would not know because they would have no idea, like they would have no idea that someone else might just come to their country who would have a prior claim over an
But
application
that,
which was
but
just.
that's why I go back to the search aspect. Even though a client would come to us and say, "Well, we want to file a UK," we would still search the Wipo database
Hmm.
just as a precautionary measure, because if they have a 2 months ahead application
Yes.
date, we cannot stop them. It is as simple as that. And this is an aspect that, of course, again, this is my shortcoming, I would say, because in India was not part of Madrid Protocol when I was working. So the thought process was never there to look at Wipo database. However, when I relocated here, it was something I learned. I was thinking, well, when India becomes part of the Madrid Protocol, which it is now for a number of years, it is an aspect to consider when we conduct searches. And in fact, as I was saying, CompuMark as an example, when we ask them to do the common law search, they will also search the Wipo database as a part of the search criteria, because they know that those applicants can restrict us. So yeah,
Got
it's
it.
definitely important to consider.
So, as you were talking about the crown dependencies and the fact that one can, if one files a trademark application in the UK, they essentially just have to provide with the certificate to these
Yeah.
dependencies. But what about the, because they have their own, these dependencies must have their own trademark systems wherein a citizen of these dependencies can just register a trademark there. So,
Correct.
what about a conflict arising there? Because since there is no opposition happening, there is no objection happening.
Yeah.
There might be cases wherein there are similar trademarks already existing there who have registered their trademarks. So,
Yeah.
how could that be dealt with?
Again, a very good question. So I'm just going to clarify a particular aspect because I think it's important before I answer the question. So with Jersey, even though they have their own something called the Trademarks Jersey Law 2000,
Mhm.
actually you are not filing a trademark application in Jersey essentially. You are simply extending the UK registration to there. So if somebody was to oppose your UK trademark, in effect, they are not a Jersey, they're not relying on a Jersey application, they are relying on a UK application. That is where the differentiation comes. So there, whereas of course we have Guernsey, which has their own system to file a trademark, and it will have to go through the same rigmarole as you would do with the UK trademark application. And Jersey and Isle of Man, again, it's the same situation where the UK trademark excels. In fact, when we renew a trademark, if we want to renew a trademark in Jersey and Isle of Man, the renewal of the UK trademark has to happen first because they rely on the UK trademark. So if you decide, actually, I'm not going to renew my UK trademark, you cannot actually renew it in Jersey or Isle of Man for that matter. So I don't know if that is the question you've asked and whether I've answered it, but please re-ask the question if you wish.
No, so what I meant to ask was that, uh, there might be conflicting trademarks, right? Like
Yeah.
since you enter the country, now you are already saying that you're just presenting the certificate, but there might be people who have already registered their similar trademarks in that particular area, who are unaware of your particular application, or like once it gets registered and it is now there. So there are two conflicting trademarks basically existing on the register. And so then I think they would have to uh, basically rely on litigation if there is something to be done about uh, that particular registration, essentially.
This question is more suitable to the Guernsey situation because they have their own national application.
Yes.
So yes, if there was an earlier trademark, absolutely. But with Jersey and Isle of Man, we have to just think of this as a double-decker bus. The ground floor is the UK trademark registration, and the first floor is the extended trademark in Jersey and Isle of Man. So the notion of conflict doesn't exist because they are both UK trademarks.
Yes.
Any conflict, you are already fighting it before the UK IPO first, before it's even going to registration. But let's assume it goes to registration and the client says, well, we want to extend protection in Jersey and Isle of Man, and then you will assist your client to do that. If somebody wants to oppose that, they still have to do it at the UK IPO because they don't have their own process to deal with this. Whereas with Guernsey, you're absolutely right. That is a different process altogether. It has it has a trademark office. There is the Ordinance Act of 2006, which is the equivalent of any trademark act in India or the UK, for example. You would have to actually go through that trademark office, file the application, examination process, objection, publication, etc., will happen there. Earlier, it used to not be the case, but since 2006, their whole system has changed completely. So,
Got it. So I have just I have one question. I'm sorry if you've already answered my question and
yeah.
I did not notice, but since you said that they don't have Isle of Man and the other one, Gibraltar, Jersey, sorry,
Yeah.
they don't have their own trademark offices, but when they file at the UK trademark office, they are only granted registration in their own areas, or does it also extend to the UK?
No, so there is no equivalent of a UK IPO or an Indian IPO in these countries, but there will be some office to administer and process the extensions of UK registrations. In Jersey specifically, there they'll have an administrative office, and in Isle of Man they'll have an administrative office. I don't know if we can call them a trademark office, but it's the best way to explain because they handle all of the extensions of the UK trademark offices in their own countries. But it is not there is no vice versa system here. You can't, because they don't have a system where you apply for a trademark at Jersey and then that extends to UK. No, it's only a one way. It's
Okay.
not a two-way system. Sorry, I don't know if this is answering your
No,
question
this is
or not.
absolutely answering my question. This is
Right.
what I was asking. Okay, so one last question that I
Yeah.
have is you talked about the initiation of cooling off period.
Yeah.
So I was like only curiously researching about the UK trademark law once, and I came across um, this fact that there is this threatened opposition that is unique to UK. There is no it doesn't exist in India. Regarding the cooling off period also, is it that I just wanted to know how does it initiate, because okay, so I did read that there is a cease and desist notice, like something, a notice that can be presented to the other party, and that is what UK IPO also encourages its the opposer to do, that first you should try to settle the dispute by yourselves. So is filing that notice the time when you like essentially initiate this cooling off period?
Right. No, so the cooling off period is only an option available once the opposition proceedings actually kick off. So
Okay.
the cooling off period does, let's look at it like this. The cooling off period does not come into question up until the actual opposition proceedings officially start. Okay. If we look at that as a separate mechanism, let's look at everything prior to the opposition proceedings starting. Just going back to what you were saying, the cease and desist letter. Yes, effectively, you are putting somebody on notice that, listen, by the way, we are going to oppose your application. In fact, we do have that practice in India because we don't have an official form at the Indian IPO to file a notice of threatened opposition. We would therefore send a C&D letter to a third party or the trademark applicant, informing them our client will want to oppose this, engage with us, talk to us. Yeah. So, but if they don't talk to us to preserve the rights of our clients' trademarks, we would file the notice of opposition before the Indian IPO. We have 3 months to do that in India. In the UK, what happens? They already have, their system allows you to file a notice of threatened opposition. This is usually done under form TM7A. There is no fee for this form, very simple and straightforward. Who are you? What are your details? What do you want to oppose? It's immediately sent across to that applicant. And then, because you have provided your information and the details, then either the applicant chooses to write to you. In many cases, they will wait out and see, are you actually going to file the notice of opposition? Because sometimes somebody can file a threatened notice, but actually don't go through with it. And then there's nothing to worry there. It will simply proceed to registration. Sometimes the registered owner legal representatives will go ahead with the notice of opposition. They will file it, and then this is when the case officer is assigned. Once you file the notice of opposition, case officer writes to both parties and they'll say, officially, this proceeding has now started. This is when the cooling off period option is available. The parties start engaging to talk, if that is the case, of course, because this depends on a case by case situation. We don't know if the parties want to talk, but if they do and they say to each other, well, actually, I think we can come up with a coexistence agreement, if that's what they decide. Or they may say, well, these are conflicting goods and services, maybe you can take these off of your application, and then our client will not continue with the opposition proceedings, and applicant agrees. They want time to be able to achieve this. That is when one of the parties can request to the case officer, we want the cooling off period. You can't ask for a cooling off period because that is a fixed time. You can only say, we want to enter into cooling off period because we are at the negotiation stage. Please allow us, please approve. And that's a fixed 9 months. You cannot say to the case officer, by the way, we want only 3 months cooling off period. It's a very fixed time period. The only option available, well, the two options available once you enter the cooling off period is, if you are coming up to the end of it and terms of negotiations haven't been concluded, both parties will seek an extension, you get another 9 months. Negotiations fall through, nothing is happening, nobody wants to, be accommodating. One of the parties can write to the case officer and say, actually, we do not wish to be in the cooling off period. Case officer will then lift the cooling off period, it's like a blanket, I would say. That is how I imagine it always. They lift the blanket, and now the fight is sort of, it starts all over again. Now they will issue sort of dates and times, and they'll say, well, now within such and such time you file your evidence, within such and such time you file your evidence, then if you want to file counters to that, hearings, etc., and then it proceeds.
Okay, understood. So there is no involvement of the IPO in the cooling off. Like they are just
No.
involved with respect to the
They are
time.
just there to help the parties if they can to a certain extent, but their role is mainly they're an arbitrator. They're the chair of this arbitration proceeding, the opposition proceeding, and therefore their responsibility is look at the trademarks manual. Can I allow these parties to get the cooling off period? Yes, I can. The rules say yes, I will do it. Basically, and then of course they are also the decision maker essentially, because once you file all of your evidence and the decision is actually given by the case officer who hears that matter. I mean, it's done both on paper and via hearings. It entirely depends again on case. Sometimes we do request hearings, sometimes it is just decided on paper, and that's fine too.
Got it. Understood. So
Yeah.
these were all my questions. Thank you for
Yeah.
answering them.
Okay.
So we have some questions from the students. First of all, they are thanking you for the informative webinar. Um, we have Abdul here who has said that he is a law student. He's a law student in Pakistan, and
Okay.
he is saying that okay, so he hopes that the law in Pakistan, trademark law in Pakistan is almost similar. So
Right.
yeah, so that is there. Okay, so we have Purahid. I'm sorry, I'm not able to Purahidka. Who has? I'm sorry if I'm pronouncing your name wrong, but she just wants to ask how long does the trademark last? So it is 10 years. The time limit. The time is 10 years in India as well as in UK, and it
Yeah.
can be renewed multiple times. So as long as as many times as you want.
Yeah, as long as you are ensuring that you're renewing your
Yes.
trademarks, whether in India, UK, or in fact even in Pakistan for that matter, since we have someone from Pakistan in the audience, that essentially a trademark can exist infinitely, I would say, because there is nothing stopping that trademark from existing. The only thing it needs is renewing. In fact, it is the only IP right which has no end date. If we were to draw comparisons, copyright also has an end date and then it falls
Mhm.
into public domain. Patent
Absolutely.
has an end date. Trademark is the only one that can keep rolling on as many years as you want. Yeah.
Definitely. So, Abhishek here doesn't have a question strictly related to the topic at hand, but
Yeah.
he wants to know about the biggest question of all, whether to go for an LLM in IP or just start practicing and gaining experience, or should both be preferred. So he has asked you this question since I introduced you, and I did mention that you have had your LLM from University of London.
Right. Okay. I mean, obviously, they are two different questions. Usually, one should do the masters mainly for personal reasons, because you will enjoy the course. It's quite an advanced course. You are given huge amounts of reading list. It really challenges your thinking. That is an LLM, whether it is in the UK, US, India, wherever. An LLM is a very advanced degree. You're not studying basics of anything. So that is mainly, I think I would recommend anybody who wants to do a master's in law to look at it as a more personal goal rather than a professional one, because I will be very honest when I say this. I have never got a job, or and nothing has ever changed because I have an LLM. But for me, it has been a personal victory and a great learning, because I ended up reading articles that I may never have. I At the time I wrote a dissertation on traditional knowledge, sui generis protection in India, which I would have never gone down that road had I not done the LLM. So the LLM is mainly a personal choice. It is entirely up to each person whether they wish to do that. Whereas I think another part of your question is, what is preferable, LLM and IP law or SQE exams? Now, again, they are two different things. This is academic. SQE is mainly to qualify in the UK as a solicitor. So that is a professional exam that one would do in the same way that somebody would do a New York bar to qualify as a US attorney. So again, this is all depends on your personal circumstances and what you feel is the right thing. The reason I have qualified under the QLTS is because I have worked here for a number of years. But had that not been the case, I may not have considered that at all, because I don't really, while I was in India, as much as we were filing a number of UK and EU trademark applications for global portfolio clients, we were not really advising them on the UK aspects because it's very complex. And also, a UK solicitor could never advise somebody who wants to file a trademark in India. They would still need an Indian counsel to give them complex advice, because otherwise it would be misleading. So I would say this is your personal choice at the end of the day. But maybe we are going to talk about this SQEQLTS at some point, Abhishek, in probably another webinar.
Absolutely.
So if anybody is interested, yeah, we will discuss that as well in the future.
So Rupali here has another question. She's
Yeah.
asking, are comparable trademarks given for crown dependencies also in case of registered trademarks at EUTM?
Yes, Rupali, because so Brexit has the same effect as it has in the UK on Jersey and Isle of Man. Of course, Brexit has no impact on Guernsey, so we can forget about that. So a comparable UK mark can be extended to Jersey and Isle of Man, because you just look at Jersey and Isle of Man as an extension of the UK trademark itself. So yes, Brexit has same impact. And also, I think it's something that I didn't mention earlier, but Jersey, although it is not a member state of the European Union, it has enjoyed a certain privilege. Again, this was in the PPT, but I'm going to quickly tell you now since you asked this question. An EU trademark registration is automatically enforced in Jersey, by the way, to anybody who's interested. And that position will not change because of Brexit, because it is something that Jersey and the European Union have agreed some many years ago. Because we are not looking at European trademarks at all, it is not something that I touched on. But because you asked this question, it's good to just point that out. But yeah, the comparable marks can be extended to Jersey and Isle of Man, same process. Get the registration, get the pay your official fee, certified copy, and you should be able to extend it out to Jersey and Isle of Man.
Okay. So we have Abdul here who is asking if so he has first of all apologized because he didn't get the point regarding the extension in other countries. So he's asking if registration of a trademark in the UK will protect the brand essentially in the UK, or is that very registration going to protect it in other countries as well?
Yeah. Okay. So the direct answer to that is a registration of a trademark in the UK will only protect it in the UK. When we say United Kingdom, we mean 4 countries put together: Northern Ireland, Scotland, England and Wales, and England and Wales, Northern Ireland, Scotland. These are the 4 countries that are part of the United Kingdom. Your registration is protected only in the UK. We were talking of crown dependencies earlier because it is something people have to be aware of, because it's a point that we miss all the time. If you're going to advise your client, given how close they sit in terms of its proximity to the UK, just when you look on the map, they are literally, I mean, we can take a ferry to Isle of Man, by the way, it's that close. So obviously, if you're going to sell your brand in the UK, you would want to consider selling it there. Before you go into that Isle of Man market, for example, how do you protect your UK trademark registration? You take your extension to Isle of Man, you have a registration there. That is why I touched on the crown dependencies aspect in this webinar today. I know this can be a bit confusing. I mean, it was confusing for me as well, given in India, we don't have this system. This is obviously a very unique thing for the UK. So Abdul, I do hope that I have clarified your question, but please type in your but please let us know if you have any other questions actually.
I don't know the person's name who has asked this question. It's
Yeah.
anonymous, but so this person has basically, stated that since Gibraltar is a part of the EU, so
Yes.
will filing trademark in Gibraltar help us, like help the person in any way regarding, the mark in the EU and then also filing the same in the UK?
Yeah. So you're sorry, I don't know, your name comes up as anonymous, but to the audience who's asked me this question, so you don't need to actually file a trademark in Gibraltar, especially the UK trademark. You don't need to, because you will simply take an extension of the UK registration to Gibraltar. But you are right in pointing out that the Gibraltar is actually part of EU. So essentially, the EU mark will cover Gibraltar, and the UK extension will protect your UK. The UK extension will also protect your trademark there. Essentially, you're doing like a double protection if you had both an EU mark and you're seeking an extension on the UK UK registration. But people do that. I mean, we've seen now, because of Brexit, a lot of the clients that we have worked with, that I am working on, generally they have an EU trademark. There is a comparable mark, but that's mainly because of the UK split from the EU. But the point is, even though their main market is the UK, they're still going to retain the EU trademark, simply because it makes more sense in the long run. That means they're still free to release their markets into the EU market or the European Union if they so wish. But having a registration is always far better than not having a registration. So again, I don't know if I have answered that question correctly, but I'm sure they will respond here if I haven't.
This was all with respect to the questions.
Yeah.
Um, yeah, and it has been like quite a lot of time. It must have been very tiring for you also, Ramya. So thanks. I would just like to thank you for being here with us today. It was really, really great to know about all of these things. It has given all of us, like including me, all of the attendees, I'm sure, to a lot to also then think about. It has definitely opened a lot of like doors of like,
Yeah.
all that the law in the trademark law in the UK contains. Because even though like we always kind of say that intellectual property is very kind of universal in nature, but there are a lot of differences which do exist with respect to territories. So it was really interesting to learn about all of this, and I'm definitely going to be listening to this webinar again sometime soon to go through things again, and then I will definitely be looking into things more. So thanks a lot for taking this webinar, Ramya. Thank you everyone for joining in and for staying through the session. It was really great to have you all. So I think we can end the webinar here. Abdul is also thanking you, and he has asked to share the relevant reading.
Yes,
So
absolutely. I think, yes, again, I apologize for the issue, the technical issue I had, and maybe I should have shared that mainly first with Abhishek before the start of this webinar. So I apologize to everybody, but I will ensure that it's sent across to Abhishek, and I'm sure he will share that with you. And, again, just going back to the QLTSSQE, I'm sure Abhishek will organize something, LawSikho will organize a webinar on that, and we may have more panelists, I hope, that day, because there is so many questions that everybody will have about these exams. But yeah, no, thank you, LawSikho, for the opportunity. It's a pleasure. Sharing knowledge is one of the most important things in this world, is what I consider. And therefore, today I've had the opportunity to share what I have learned over the last few years working in the UK. And I would also look forward to attending some more webinars of LawSikho and learning from other panelists. So thank you. Thank you very much, everyone.
Thank you. Thank you, Ramya. Okay, everyone, good night. Bye. Bye, Ramya.